You're operating a commercial enterprise on HOA designated recreational land. You have 14 days to cease all activity, remove all structures, and restore the area to its natural condition, or we will pursue enforcement action. She said it the way someone says a sentence they have rehearsed in a mirror, standing at the rim of Crestfall Canyon with a clipboard pressed against her blazer and the September wind pulling at her hair. Behind her, 2 other board members stood in a loose formation, nodding at intervals, the way people nod when they want to appear to have read the documents they are holding. Down in the canyon below us, maybe 180 feet down, where the red sandstone walls narrowed to a throat of shadow before opening again into the wide gravel wash, I could still see the zipline anchor hardware bolted into my rock, my canyon walls, my 10,200 acres. They had no idea. Drop a comment. Tell me where you're from, and if something like this has ever happened to you, I want to hear it. The woman's name was Renata Voss. She was the president of the Crestfall Ridge Homeowners Association, a position she had held for 3 years and which she treated with the gravity of a federal appointment. She had driven out in a white SUV with the HOA logo on the door, and she stood there at the canyon rim as though the land beneath her feet had always been hers to administer. The wind off the canyon smelled of juniper and dry stone, the smell of every autumn I had known on this property since I was 7 years old. I looked at her clipboard. I looked at the canyon. I said nothing, because there was nothing urgent to say. The deed was in a fireproof drawer in the ranch office 40 yards behind me. Let me take you back to where this started. My grandfather, Elias Croft, homesteaded the original 6,400 acres of what would become the Crestfall Ranch in 1931. He was 24 years old, a dry land farmer from eastern New Mexico who had followed a surveyor's rumor about canyon-cut grazing land in the high desert of the Colorado Plateau. He arrived with a wagon, a team of 2 horses, and a hand-drawn map that turned out to be more optimistic than accurate. What he found was better than the map suggested. The canyon, Crestfall Canyon, as the county would eventually name it, ran nearly 3 miles through the center of the property, its walls rising between 150 and 220 feet, its floor fed by a seasonal creek that ran clear and cold from March through July. Elias filed his homestead claim at the county recorder's office in October of 1931. The original instrument, Deed Book 14, page 312, Harmon County, described the parcel in metes and bounds with a precision that still holds up today. He built a stone house on the North Mesa, ran cattle on the canyon floor in the dry months, and cut cedar fence posts from the rimrock timber every winter. My father, Gerald Croft, expanded the holding twice. The first acquisition came in 1967, when a neighboring family sold 2,100 acres of mesa and canyon rim to the south, the parcel that would eventually become the most contested ground in this entire story. The second came in 1979, another 1,700 acres to the east, bringing the total to just over 10,200 acres. Gerald recorded both deeds promptly, paid his property taxes without interruption, and maintained the boundary fences himself until his knees gave out in the early 1990s. I grew up on this land. I learned to read a topographic map in this kitchen, to set a corner monument with this family's transit level, to recognize the difference between a recorded easement and a gentleman's agreement by the time I was old enough to drive a truck. My name is Owen Croft. I am a licensed civil engineer. I worked for a regional land survey firm for 22 years before returning to the ranch full-time after my father's death in 2011. I inherited the property outright, all 10,200 acres, the canyon, the mesa, the old stone house, the water rights, and the deed that described every inch of it. I kept the deed in a fireproof steel cabinet in the ranch office in a manila folder labeled simply, Croft Ranch, Original Instrument. I also kept in the same cabinet every survey, every tax receipt, every recorded easement, and every piece of correspondence related to the property going back to 1931. My grandfather had started the archive. My father had continued it. I had organized it, indexed it, and added to it every year. I mention this because it matters. It matters a great deal. The Crestfall Ridge development went in on the mesa south of the canyon between 2004 and 2008. A developer named Pinnacle West Land Group had purchased a 900-acre parcel from a family called the Dunbars, land that abutted my southern boundary but did not cross it. Pinnacle West built 214 homes on that mesa, platted the subdivision, recorded the CC and Rs, and formed the Crestfall Ridge Homeowners Association to manage the common areas. The development was legal. The HOA was legal. Their 900 acres were their 900 acres, and my 10,200 acres were mine. And for several years, everyone seemed to understand this arrangement without needing to discuss it. The canyon was the problem. Or, rather, the canyon was the opportunity, which is how Renata Voss and the Crestfall Ridge HOA board had come to think of it. Crestfall Canyon does not belong to the HOA. It has never belonged to the HOA. It does not touch the HOA's 900 acres except at one narrow point along the southern rim, where my boundary line runs within 60 feet of their northernmost common area. The canyon is entirely within my deeded property. The access road that runs from the subdivision down to the canyon floor crosses my land under a recorded access easement. Easement Instrument 2006-4471, Harmon County, that I had granted to Pinnacle West during the development phase for emergency vehicle access only, not recreational access, not commercial access, emergency access only. That language was specific, deliberate, and recorded. I had not thought about that easement in years. I had not needed to. The first letter arrived on a Tuesday morning in late April. It came by certified mail, return receipt requested, on Crestfall Ridge HOA letterhead. The letter informed me that the HOA had been operating a recreational program in Crestfall Canyon for the past 2 seasons. A zip line tour, it said, offering guided descents along the canyon's north wall, and that the board was formally requesting my cooperation in establishing a long-term recreational use agreement. The letter was signed by Renata Voss, president, and by a man named Dale Fitch, who was listed as the HOA's Recreation and Amenities Director. The tone was polite, almost breezy, as though they were asking me to share a driveway rather than informing me that they had been running a commercial operation on my private property without my knowledge or consent. I read the letter twice. I set it on the kitchen table. I went outside and walked to the canyon rim and looked down at the north wall, and there they were. 2 steel anchor points, each bolted into the sandstone with 4-inch expansion anchors, a steel cable running between them, and a lower terminus platform of pressure-treated lumber cantilevered off a ledge about 40 feet above the canyon floor. The hardware was commercial grade. The platform had a railing. There was a small sign on the platform that I could not read from the rim, but I could see it was printed, not handwritten. I was not angry. I wanted to be clear about that. What I felt, standing at the rim of Crestfall Canyon looking at steel bolted into my rock, was something closer to a quiet, methodical attention. The same attention I bring to a survey discrepancy or a structural calculation that does not close. Something was wrong. The record would say what. I went back inside and pulled out the ranch archive. I found the 2006 easement instrument and read every word of it. Emergency vehicle access only. No recreational use, no commercial activity, no permanent structures. The easement was recorded, indexed, and unambiguous. I found the original plat of the Crestfall Ridge subdivision, filed with Harmon County in 2005, and traced the boundary lines with my finger. Their property ended at the mesa edge, the canyon rim, the canyon walls, the canyon floor. All of it was on my side of the line. I did not respond to the letter immediately. Instead, I called my neighbor to the north, a rancher named Pete Aldecoa, who had lived adjacent to the Crestfall Ridge development since it was built, and who had a habit of noticing things. Pete told me the zip line had been running on weekends since the previous spring. He had seen vehicles, not HOA vehicles, but private cars and a van with a logo on the side, parking at the canyon access road and walking groups down toward the rim. He said he had assumed I knew about it. He said he was glad I had called. I thanked Pete and wrote down what he had told me. Then I called my attorney, a woman named Claire Sato, who had handled the estate transfer when my father died and who knew the Croft Ranch deed the way a good doctor knows a patient's chart. I read her the HOA's letter over the phone. There was a pause on her end, the kind of pause that means someone is choosing their words carefully. She said, "Owen, they are operating a commercial enterprise on your private property under an easement that does not permit it." I said I had read it the same way. She said we should meet. We met at her office in Harmon the following week. I brought the archive, the original deed, the 2006 easement instrument, the subdivision plat, and a set of photographs I had taken at the canyon rim the day after the letter arrived. Claire spread everything across her conference table and went through it methodically, the way she always did, making small notes in the margin of a yellow legal pad. When she finished, she looked up and said, "The easement language is unambiguous. Emergency vehicle access only. There is no recreational use provision, no commercial activity provision, and no authorization for permanent structures of any kind." She tapped the photograph of the anchor bolts with her pen. "Those are permanent structures." She said it the way a person states a fact that requires no elaboration. I told her I wanted to proceed carefully. I told her I was not interested in a confrontation. I was interested in the record. She said that was exactly the right instinct. She drafted a formal response to Renata Voss's letter, which went out by certified mail the following Friday. The letter was 4 paragraphs. It acknowledged receipt of the HOA's request. It noted that the canyon and all structures within it were located on private property owned by Owen Gerald Croft, as recorded in Deed Book 14, page 312, and subsequent instruments, Harmon County Recorder's Office. It noted that the access easement governing the only legal entry point to the canyon, Easement Instrument 2006-4471, permitted emergency vehicle access only and did not authorize recreational use, commercial activity, or the installation of permanent structures. It requested, in writing, that the HOA provide any legal instrument it believed authorized its activities in the canyon, and that it ceased those activities immediately pending that response. The letter was polite. It was precise. It cited every instrument by number and recording date. Claire signed it on firm letterhead. I kept a copy in the archive. The HOA's response arrived 12 days later. It was not what I expected. The letter, again signed by Renata Voss, did not cite a legal instrument. It did not reference a deed, an easement, a recorded covenant, or a plat. What it said, in language that became more florid as it went on, was that Crestfall Canyon had been used by the Crestfall Ridge community for recreational purposes since the development's founding, that this use had been open, continuous, and uncontested for a sufficient period to establish a prescriptive easement under Colorado law, and that the HOA therefore had a legal right to continue and expand its recreational programming in the canyon. It also said, and this was the sentence I read 3 times, that the HOA board had voted to assess a compliance fine against my property for failure to cooperate with community recreational standards. A fine against my property for not cooperating with an activity conducted on my land without my permission. I set the letter on the kitchen table beside the first one. I looked at the 2 of them for a moment. Then I pulled out a fresh folder, labeled it Crestfall Ridge HOA Correspondence, and filed both letters in chronological order. Claire had anticipated the prescriptive easement argument. When I called her that afternoon, she was already thinking about it. She said that a prescriptive easement under Colorado law requires open, continuous, hostile, and actual use for a period of 18 years. The statutory period under CRS Section 3841-101. She said the zip line had been operating, by the HOA's own admission in their first letter, for 2 seasons. 2 seasons was not 18 years. It was not close to 18 years. She said the claim had no legal foundation, and that the HOA had now put that claim in writing on their own letterhead, which was, she said, a gift. I asked her what she meant by a gift. She said, "They have told us their theory. Now we can address it directly and on the record before they have time to build anything further." She paused. "Owen, this is going to go to court. I want you to be prepared for that." I told her I was prepared. I had the deed. I had the easement. I had the survey. I had the photographs. I had Pete Aldecoa. I had the archive my grandfather had started in 1931. I told her to file whatever needed to be filed. She filed a complaint in Harmon County District Court the following month, Croft versus Crestfall Ridge Homeowners Association, seeking a declaratory judgment confirming my ownership of the canyon and all structures within it, an injunction against further use of the access easement for recreational or commercial purposes, removal of all unauthorized structures at the HOA's expense, and damages for trespass and unauthorized commercial use. The complaint cited the deed, the easement instrument, the subdivision plat, and the HOA's own letters as exhibits. It was 41 pages, with attachments. The morning Claire filed it, I drove out to the canyon rim and stood there in the early light, the way I had stood there 100 times before. The sandstone was cold under my boots. The creek, far below, caught the first sun and held it for a moment, bright and still, before the shadow of the east wall moved across it. The anchor bolts were still in the rock. They would not be there much longer. The record had been opened. Now it would speak. The HOA's attorney entered the picture about 3 weeks after Claire filed the complaint. His name was Bryce Kellerman, and he practiced out of a firm in Grand Junction that handled, among other things, homeowners association disputes across the western slope. He sent a letter to Claire's office that arrived on a Thursday morning, and Claire forwarded it to me with a single line of her own appended at the bottom. Read paragraph 4 carefully. I read paragraph 4 carefully. It said that the Crestfall Ridge HOA disputed the characterization of the access easement as limiting recreational use, and that the HOA's position was that the easement language, read in context with the original development agreement between Pinnacle West Land Group and Harmon County, created an implied right of recreational access to the canyon for all residents of the Crestfall Ridge subdivision. It further stated that the HOA intended to file a counterclaim asserting that implied right, and that it would seek a declaratory judgment of its own establishing the canyon as a community recreational amenity. An implied right. Implied by a development agreement between a developer and a county, neither of which had owned my land or had any authority to encumber it. I called Claire that afternoon. She was already working. She had pulled the original development agreement between Pinnacle West and Harmon County from the county recorder's office, instrument 2005-2187, and she had read every page of it. She told me that the agreement addressed road improvements, utility easements, and stormwater management. It said nothing about Crestfall Canyon. It said nothing about recreational access to any land beyond the platted subdivision boundaries. It did not mention my name, my family's name, or the Croft Ranch deed. It had no legal authority over my property whatsoever, because Pinnacle West had never owned my property, and a developer cannot grant rights in land it does not hold title to. That is not a subtle legal point. That is a foundational principle of property law so basic that it appears in the first semester of any first-year property course. Claire said it quietly, without emphasis, the way she said things that did not require emphasis. She said she wanted to commission a new survey. Not because the boundary was in doubt. It was not in doubt, not to anyone who had read the instruments, but because in litigation, a fresh survey from a licensed professional reduces a contested line to a fact and evidence rather than an argument between lawyers. I agreed immediately. I knew the surveyor she had in mind, a man named Frank Delacroix, who had worked in Harmon County for 31 years and who had, as it happened, performed a boundary survey of the Croft Ranch's southern perimeter in 1998, when my father had briefly considered selling a small parcel of mesa land and then decided against it. Frank still had his field notes from that survey in his office. He told me so when I called him, and I could hear him pulling the drawer open as we spoke, the dry rustle of paper that had been waiting 13 years to be useful again. Frank came out to the ranch on a morning when the air carried the first cold edge of the season coming, the smell of juniper sharpened by something thinner and higher, the smell of altitude dropping its temperature like a stone. He walked the southern boundary with his equipment and his assistant, a young man named Torres, who carried the rod and said very little. Frank set up at the original corner monuments, the iron pins my grandfather had set in 1931, and that my father had re-verified in 1967 when the Dunbar parcel was acquired. And he ran his traverse from the southwest corner to the southeast corner along the canyon rim. It took most of the day. I walked with him for part of it, not to supervise, but because I had walked that boundary with my father and I knew where the monuments were, and Frank appreciated that. At the point where the canyon rim swung north and the HOA's northernmost common area came within 60 feet of my line, Frank stopped and looked at his instrument and looked at the ground and looked at his instrument again. He said, "The line is exactly where the deed says it is." He said it without looking up. He said it the way a man states something he already knew but wanted to confirm for the record. The survey report came back certified and sealed. It placed the Croft Ranch's southern boundary at the precise meets and bounds description in Deed, Book 14, page 312, with a closure error of less than 1 part in 40,000, well within the tolerance for a survey of this type and vintage. The canyon rim, the canyon walls, the canyon floor, and every structure attached to any of them were entirely within the Croft Ranch boundary. The HOA's northernmost common area ended at the mesa edge, 62 feet north of my line at the closest point. Frank's report was 38 pages, with field notes, traverse calculations, and a scaled plat showing the boundary in relation to the canyon and the subdivision. Claire filed it as a supplemental exhibit in the district court case. Around this same time, Pete Aldecoa called me on a Sunday evening. He had been talking to some of the Crestfall Ridge homeowners, not the board members, but the ordinary residents, the people who had bought houses on the mesa without any particular interest in canyon governance. He said a number of them had been buying tickets. That was the word he used, tickets. He said that the zip line operation had not been a free community amenity. It had been a ticketed tour, offered through a website, open to the public, priced at $65 per person for a guided descent and return. He said some of the homeowners had only recently learned this, and that several of them were unhappy about it, because the HOA's marketing materials had described the Canyon program as a resident benefit, but the ticket revenue had apparently been flowing into a separate account rather than into the HOA's general operating fund. I asked Pete how he knew about the separate account. He said one of the homeowners, a retired accountant named Gail Mendenhall, who had lived in the subdivision since 2009, had asked to see the HOA's financial records at the last annual meeting and had been told the Canyon program finances were handled separately and were not subject to the standard HOA disclosure requirements. Gail had not accepted that answer. She had retained her own attorney and filed a formal records request under Colorado's nonprofit corporation statutes, specifically CRS Section 7136106, which requires a nonprofit to make its financial records available to its members upon written demand. The request had been filed. The HOA had not yet responded. I thanked Pete. I called Claire. I told her what Pete had told me about the ticket revenue and the separate account. There was the kind of pause on her end that I had come to recognize as the sound of a legal theory organizing itself. She said, "Owen, if they were selling public tickets to a commercial zipline operation on your private property and routing that revenue off the books, that is not just a trespass claim anymore." She said it carefully, but she said it. She said she wanted to request the HOA's financial records as part of discovery in the district court case, and that she would coordinate with Gail Mendenhall's attorney so the requests did not duplicate each other unnecessarily. I told her to proceed. I went to the archive and pulled the folder labeled Crestfall Ridge HOA Correspondence. I added a new sheet of paper behind the 2 letters with Pete's account written out in my own hand, dated and signed, the way my grandfather had dated and signed his field notes, the way my father had dated and signed his tax receipts. The archive had always been a living document. It was living still. Owen Croft had been building a case the way his grandfather had built fence lines, post by post, corner by corner, with no hurry and no shortcuts. The survey was in. The development agreement had said nothing about the canyon. The easement said emergency access only. And now there was a ticketed commercial operation, a separate financial account, and a homeowner with a lawyer asking questions the board did not want to answer. He had not raised his voice once. He had not needed to. The paper was doing the work exactly as it was supposed to. What comes next is the part where the record stops being a collection of documents and starts being a verdict. Stay with me. Claire filed the discovery request for the HOA's financial records on a Wednesday, and Bryce Kellerman objected within the week on the grounds that the Canyon program's finances were proprietary and outside the scope of the trespass and easement dispute. The objection was filed in writing, which meant it was now part of the court record, which meant that the HOA had now told a district court judge in a signed pleading that the financial details of a commercial operation conducted on private property were none of the property owner's business. The judge did not agree. Her name was the Honorable Patricia Serrano, and she had served on the Harmon County District Court bench for 14 years. She ruled on the discovery objection at a brief hearing in her courtroom, a small, wood-paneled room that smelled of old paper and the particular stillness of a place where arguments had been made and resolved for a long time. I sat behind Claire at the plaintiff's table. Renata Voss sat behind Bryce Kellerman at the defense table, in a blazer the color of slate, with a leather portfolio open in front of her. Judge Serrano read the objection, read Claire's response, and looked up over her reading glasses. She said that the financial records of the Canyon operation were directly relevant to the question of whether the HOA had been conducting a commercial enterprise on the plaintiff's property, which was precisely the question before the court, and that the objection was overruled. She said the HOA had 14 days to produce all financial records related to the Canyon program, including bank statements, ticket revenue records, vendor contracts, and any correspondence related to the program's financial management. 14 days. The same number Renata Voss had given me, standing at the canyon rim with her clipboard, the September wind in her hair. The records arrived on the 12th day in 2 banker's boxes delivered to Claire's office. Claire called me the evening she finished going through them. She was quiet for a moment before she spoke, the kind of quiet that precedes something that requires careful handling. She said that the Canyon program had generated approximately $218,000 in ticket revenue over the 22 months it had been operating. She said that revenue had been deposited into an account held not in the HOA's name, but in the name of a limited liability company called Canyon Ridge Recreation, LLC, which had been registered with the Colorado Secretary of State in March of the previous year. The registered agent of Canyon Ridge Recreation, LLC, was Dale Fitch, the HOA's Recreation and Amenities Director, the second name on the original letter requesting my cooperation. She said that the HOA's General Operating Fund had received no portion of that revenue. She said that the vendor contracts in the boxes included an agreement with a zipline equipment company, an agreement with a liability insurance carrier, and an agreement with a guide services firm, all signed by Dale Fitch, none of them referencing the HOA as a party, all of them executed in Canyon Ridge Recreation, LLC's name. She said that the HOA's own financial disclosures to its members had described the Canyon program as a resident amenity, funded by the HOA's operating budget, which was inconsistent with the records now in her possession. I listened to all of this without speaking. When she finished, I asked her what it meant in practical terms. She said it meant that someone had been running a private commercial business on my property, using the HOA's name and the HOA's access road as the delivery mechanism, while keeping the revenue in a separate entity that did not belong to the HOA or its members. She said it meant the trespass was not an institutional oversight. It was a private commercial enterprise conducted under institutional cover. She said she was going to amend the complaint. I sat at the kitchen table for a long time after that call, in the particular quiet of a ranch house at night when the wind is dropped and the only sound is the cooling of the walls. The 2 original letters from Renata Voss were still in the archive in their folder, in the fireproof cabinet. The survey was in there. The deed was in there. And now, in Claire's office across town, 2 bankers' boxes of financial records sat under the fluorescent light, telling a story that no one on the HOA board had anticipated anyone would ever be in a position to read. The archive my grandfather had started in 1931 had grown by 2 boxes. Claire amended the complaint on a Friday morning, and the amended filing was 47 pages with 6 additional exhibits. She added claims for unjust enrichment, conversion of property for private commercial gain, and fraud on the HOA membership. The last of those claims directed not at the association as a whole, but at Dale Fitch individually, in his capacity as the registered agent and sole beneficiary of Canyon Ridge Recreation, LLC. She also added Renata Voss as a named individual defendant, on the grounds that the financial records produced in discovery included a series of email exchanges between Voss and Fitch, in which Voss had been informed of the LLC's existence, the separate account, and the ticket pricing structure, and had responded with language that suggested not only awareness, but approval. One of those emails, sent by Voss to Fitch in the previous October, read, "Keep the Canyon revenue separate. If the members ask, it's a management fee arrangement." Claire had highlighted that sentence in yellow on the exhibit copy she sent me, and I had read it 3 times, not because it was difficult to understand, but because it was exactly the kind of sentence that a careful reader files away and does not forget. I was not angry when I read it. I want to be clear about that. What I felt was something more like recognition, the feeling of a survey traverse that has been running in one direction for a long time and has finally closed back on its starting point. The line was complete. The error was 0. The hearing on the amended complaint was set for a Thursday in November in Judge Serrano's courtroom. The morning was cold in the way that November mornings in the Canyon country are cold, a dry, still cold that settles into the rock and does not lift until well past noon, the kind of cold that makes the juniper smell sharper and the sandstone look darker than it is. I drove into Harmon in the early light, the canyon road running south through the mesa grass, frost on the fence wire, the sky the particular deep blue that comes before the sun has fully committed to the day. I had the archive in a box on the passenger seat, though Claire had copies of everything. I brought it because my grandfather had started it and my father had continued it, and it belonged in the room. The courtroom was as I remembered it from the discovery hearing. The wood paneling, the stillness, the smell of old paper and institutional patience. Claire was already at the plaintiff's table when I arrived, her legal pad open, her pen uncapped, her notes written in the small, precise hand that I had come to associate with the feeling that things were organized and would proceed in order. Bryce Kellerman was at the defense table with a younger associate I had not seen before. Renata Voss sat behind them in the gallery, not at the table, because she was now a named defendant and her own separate counsel, a woman named Audrey Park from a firm in Denver, sat beside her. Dale Fitch was not present. His attorney had filed a motion for a continuance on his behalf, citing scheduling conflicts which Judge Serrano had denied. The hearing was not a trial. It was a hearing on Claire's motion for summary judgment on the core ownership and easement claims, and on the preliminary injunction requiring the HOA to cease all canyon operations immediately. Judge Serrano had read the briefs. She had the survey. She had the deed. She had the development agreement that said nothing about the canyon. She had the easement instrument that said emergency vehicle access only. She had the HOA's own letters, in which they had stated their legal theory in writing, and she had Claire's brief demonstrating, citation by citation, that the theory had no foundation in the recorded instruments or in Colorado property law. Bryce Kellerman argued for 40 minutes. He was a competent attorney, and he argued what he had, which was a prescriptive easement theory built on 2 seasons of zipline operations, an implied rights theory built on a development agreement that did not mention the canyon, and a community reliance argument that amounted to saying the HOA's members had expected to use the canyon, and it would be unfair to take that expectation away. Judge Serrano listened without interrupting. When he finished, she asked him one question. She said, "Mr. Kellerman, can you direct me to any recorded instrument, any deed, any easement, any covenant, any plat, any agreement that conveys to the Crestfall Ridge Homeowners Association or its members any right of access to or use of Crestfall Canyon as described in Deed Book 14, page 312, Harmon County Recorder's Office?" Kellerman was quiet for a moment. He said that the implied rights theory did not require a specific recorded instrument, that it arose from the totality of the development context. Judge Serrano said, "That is not what I asked." She asked the question again, exactly as she had phrased it the first time. Kellerman said he could not point to a specific recorded instrument. Judge Serrano wrote something on her pad. She looked up. She said, "Then the answer to the question is that there is no such instrument, and without a recorded instrument or a statutory period of prescriptive use, which the HOA's own correspondence confirms has not been met, there is no legal basis for the claimed right." She said it without raising her voice. She said it the way a person states a conclusion that the evidence has already reached without her. She granted summary judgment on the ownership and easement claims. She granted the preliminary injunction. She ordered the HOA to cease all access to the canyon through the emergency easement for any purpose other than emergency vehicle access, effective immediately. She ordered the removal of all structures, the anchor points, the cable, the terminus platform, the signage, within 30 days at the HOA's expense. She scheduled a separate evidentiary hearing on the fraud and unjust enrichment claims against Voss and Fitch individually, to be held 60 days out, and she noted on the record that the financial documents produced in discovery raised questions that went beyond the scope of the civil case before her, and that she was referring the matter to the Harmon County District Attorney's Office for review. That last sentence landed in the courtroom the way a stone lands in still water. Not loudly, but with a spread of consequence that kept moving outward long after the sound was gone. Claire turned to me at the plaintiff's table and said quietly, "That's the record speaking." I nodded. I did not say anything else. There was nothing else that needed to be said. What followed in the weeks and months after that hearing was the kind of institutional unraveling that happens not with drama but with paperwork, one filing at a time. The Harmon County District Attorney's Office opened an inquiry into Canyon Ridge Recreation, LLC, and into the financial conduct of Dale Fitch and Renata Voss. That inquiry was ongoing at the time of this telling, and I will not speculate about its outcome, because speculation is not what this story is about. What I can tell you is that the HOA's board, faced with the amended complaint naming Voss individually, voted at a special meeting to remove her as president. The vote was 7-2. The minutes of that meeting were a matter of public record, filed with the HOA's registered agent in Harmon County, and Pete Aldecoa called me the morning after the meeting to tell me about it. He said Gail Mendenhall had seconded the motion to remove her. He said it had been a quiet meeting, no raised voices, just a vote and a result. I told him that was exactly how it should go. Dale Fitch resigned as Recreation and Amenities Director the same week, before the evidentiary hearing on the fraud claims. Canyon Ridge Recreation, LLC, was dissolved by the Colorado Secretary of State for failure to file its annual report. A small administrative ending for an enterprise that had taken $218,000 from the public and conducted its business on land it had no right to enter. The evidentiary hearing was continued, then continued again, and eventually resolved through a settlement that Claire negotiated on my behalf. The terms of that settlement included full reimbursement of my legal fees, a payment representing the fair market rental value of the commercial use of my property for 22 months, and a formal recorded instrument, filed with the Harmon County Recorder's Office, vacating any claim the HOA or its successors might assert to recreational access to Crestfall Canyon. That instrument was recorded on a Tuesday in February in the same recorder's office where my grandfather had filed his homestead claim in October of 1931. The recording number is in the archive in a new folder behind the survey and the deed. The anchor bolts came out of my rock on a cold morning in December, removed by a contractor the HOA had hired to comply with the court's order. I was there when they did it. I stood at the canyon rim and watched the work crew rappel down the sandstone and drill out the expansion anchors one by one. The sound of the impact driver carrying up the canyon walls and dissolving into the open air above. The platform came apart in sections. The cable was coiled and carried out. When they were done, the canyon wall was clean sandstone again, the bolt holes the only evidence that anything had ever been there, and those would weather in time. I stood at the rim for a while after the crew left, in the cold December stillness, and looked down at the canyon floor the way I'd looked down at it every autumn since I was 7 years old. The creek was frozen along its edges, the center still running thin and clear over the gravel, catching the low winter light the way it always had. The sandstone walls rose around it, red and patient, the way they had risen for my grandfather and my father before me. The cedar fence posts along the south boundary line were still standing, the same line Frank Delacroix's survey had confirmed to the nearest hundredth of a foot. The land was exactly what the deed said it was. It had always been. What this story comes down to is not complicated, though the path through it was long. When an institution with apparent authority makes a claim against your property, a fine, a demand, an assertion of rights, the first question is not whether to comply. The first question is whether the claim has a legal foundation, not a social foundation, not a community expectation, not an assumption that has gone unchallenged because no one thought to challenge it. A legal foundation, a recorded instrument, A deed, an easement, a covenant, a statute. Something in the record. Because the record does not care about confidence or blazers or clipboards or the rehearsed certainty of someone who has mistaken apparent authority for actual authority. The record only cares about what was filed, what was signed, what was indexed, and what the instruments say. My grandfather understood this in 1931. My father understood it in 1967. I understood it on a September morning when a woman stood at the rim of my canyon and told me I had 14 days to comply. The deed was 40 yards behind me. The answer was already in the record. It had been there for 90 years. If you have land or a boundary line or a deed in a drawer somewhere, and someone has ever told you that you have no right to what you hold, leave a comment. I want to hear your story. And if you want to follow the next case, which involves a water rights dispute and a dam that 3 different parties all believe they own, the subscribe button is there when you're ready.